Good morning, Ma'am Rada. Good morning, classmates. My topic that I will discuss to you is the faithful application of safeguards against invasion of the freedom of expression is paramount in the trial of a libel case 167 SCRAA 422-1988. So before we start, I would like to give you first the meaning and purpose of freedom of expression. Freedom of expression refers to the ability of an individual or group of individuals to express their beliefs, thoughts, ideas, and emotions about different issues free from government censorship. Some scholars group several of those freedoms under the general term freedom of expression. Freedom of expression is a fundamental human right. It reinforces all other human rights, allowing society to develop and progress. The ability to express our opinion and speak freely is essential to bring about change in society. So let's now proceed to the references that I preferred for this topic. And it is Southeastern College Incorporation, the petitioner, versus Court of Appeals Juanita de Jesus de Maano, Emerita de Maano, Remedios de Maano, Consolacion de Maano, and Milagros de Maano, the respondents. GR number 126389, July 10, 1998, Purisima J. Private respondents are owners of a house of 326 College Road, Pasay City, while petitioner owns a 4-story school building along the same College Road. On October 11, 1989, at about 6:30 in the morning, a powerful typhoon Saling hit Metro Manila. Buffeted by very strong winds, the roof of petitioner's building was partly ripped off and blown away, landing on and destroying portions of the roofing of private respondent's house. After the typhoon had passed, an ocular inspection of the destroyed building was conducted by a team of engineers headed by the city building official engineer Jesus L. Reyna. Pertinent aspects of the latter's report dated October 18, 1989 stated as follows. We have two factors in this situation. First, one of the factors that may have led to this calamitous event is the formation of the building in the area and the general direction of the wind. Situated in the peripheral lot is an almost U-shaped formation of 4-story building. Thus, with the strong winds having a westerly direction, the general formation of the building becomes a big funnel-like structure. The one situated along College Road receiving the heaviest impact of the strong winds. Next factor, and perhaps the most likely reason for the dislodging of the roofing structural trusses, is the improper anchorage of the said trusses of the roof beams. The 1/2 diameter steel bars embedded in the concrete roof's beams, which serve as truss anchorage, are not bolted even bent to the trusses. Thus, those trusses are not anchored at all the roof beams. Let's now proceed to the safeguard or respondent's defense in this case. In their compliance 6 before the Regional Trial Court of Pasay City, Branch 117 for damages based on culpa aceliana, private respondents alleged that the damage to their house rendered the same uninhabitable, forcing them to stay temporarily in others' houses, and so they sought to recover from petitioner 117,116,000 as actual damages, 1 million as moral damages, 300 million as exemplary damages, and 100 million for and as attorney's fees, plus cost. In its answer, petitioner averred that subject school building had withstood several devastating typhoons and other calamities in the past. without its roofing or any portion thereof giving way. That it has not been remiss in its responsibility to see it that said school building, which houses school children, faculty members, and employees, is in top condition, and furthermore, Typhoon Saling was an act of God, and therefore beyond human control, such as petitioner cannot be answerable for the damages wrought thereby, absent any negligence on its part. This is the petitioner's defense. At the outset, it bears emphasizing that a person claiming damages for the negligence of another has the burden of providing the existence of fault or negligence causative of his injury or loss. The facts constitutive of negligence must be affirmatively established by competent evidence. 19. Not merely by presumptions and conclusions without basis in fact. Private respondents, in establishing the culpability of petitioner, merely relied on the aforementioned report submitted by a team which made an ocular inspection of petitioner's school building after the typhoon. As the term imparts, an ocular inspection is one by means of actual sight or viewing. 20. What is visual to the eye through is not always reflective of the real cause behind. For instance, one who hears a gunshot then sees a wounded person cannot always definitely conclude that a third person shot the victim. It could have been self-inflicted or caused accidentally by a stray bullet. The relationship of cause and effect must be clearly shown. Wherefore, the petition is granted and the challenged decision is reversed. The complaint of private respondents in civil case number 7314 before the trial court, a SCRAA is ordered dismissed and the writ of execution issued on April 1, 1993 in said case is set aside. Accordingly, private respondents are ordered to return to petitioner any amount or property received by them by virtue of said writ, cause against the private respondents.